Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is April 7th, 2016. This is our bi-weekly community conference call every other Thursday, where we try to assist as best as we can with answers to your commonly asked questions. This is not a substitute for a one-on-one consultation, but we still try to guide you as best as we can. When you log in, we have a recording that explains to you the limits of this call, so I won't go over it again. That said, let's get started on the questions that have been posted. I'll start with the questions I have marked as frequently asked questions first, and invite any other follow-up questions on those frequently asked questions. Then I'll start on the posted questions. And if time permits, we'll then take new questions. Okay. So the first question from Yeber is about a gap in status. So project is going to end on April 29th on H1. H4 is kicking in on May 2nd. So there's a couple of days gap in there. Do I need to have my salary slip go to May 1st? Look, these kinds of de minimis small gaps are sometimes even a product of the way the government works. In your case, I don't think it's going to be a problem. Couple of days here and there, but technically, yes, even for one day being out of status, the government can say, okay, you're out of status. But when they have already approved your status, H4, and I'm assuming the H4 was approved with an I-94 attached, I don't think this is going to be a major issue. Okay. If you are nervous about it, go ahead and cover yourself all the way to May 1st. But I really don't see any need for us to be nervous. There are situations. I'll give you another example. This is very common. So let's say I file an H1 extension. Okay. I filed the extension before the current H1 expires, or L1, or O1, or P visa, or E visa. All these visas have a similar problem. I file it. After I filed it a week later, it expires, but I can continue working up to 240 days because the law allows me to do so. If they approve my case 3 months later, they are not going to approve it effective today. They're going to approve it effective the date of approval. So there's a 3-month gap in status. Is that a problem? No. This is just a matter of process. So in your case, that is not the situation. But there are cases, that's why I marked it as a frequently asked question, that there are situations where these things can happen, and some of it is just built into the process. And normally we don't need to worry about it, but you did the right thing. Double check it, make sure that this is one of the cases where you do not have to worry about it. I've also said look at question number 12. So I'm going to scroll down to question number 12. I guess that's a related question. And that's from Ria. Ria said, currently on H1B, and my H4 is effective 15th July 2016. I had requested USCIS to give H4 effective date of 13th May, as my project was ending on 13th May 2016, but the request was not honored. And they said because the beneficiary will change status, we cannot give an earlier date than what is shown on the I-129 approval. So if my project ends on 13th May, should I leave the country because H4 is effective July 15th? I personally think it's still not a big issue, because if you've got the H4 already with an I-94 attached, I doubt very much the government is going to make an issue of it. But you can do another thing. You can file a tourist visa to cover you for those 2 months, but make sure it does not go beyond July 14th, okay? Because otherwise your status will be changed to B. So you could do a stopgap kind of arrangement if you wanted, or you can leave USA for a couple of months. But even if you stayed, I doubt very much it's going to be an issue. Can they make an issue of it? Sure. But are they likely to? I don't think so. Okay, so these were the frequently asked questions about gaps in status. if you have any follow-ups on gap in status type of a situation, anyone, press *5 on your phone. Anyone who has a gap question, press *5. No new questions, just gap questions. Okay, nobody? Let's go on to the next question I have marked as frequently asked. I think there is 3 of them today. So what do I do? This is from a community member Sachin, who is getting married while his I-485 employment based is pending. Another common situation. First of all, generally speaking, remember the law is if you have an employment based case pending and you are married on the date your green card is approved. Before your green card is approved, you're already married, she's entitled to come through you through the same priority date and through a much shorter process called following to join. Following to join. Okay. What is following to join? Let's say you are here, Sachin, and your wife is you got married one day before your 45 was approved. So you're already a green card holder. She's in India. You will file form I-824 and request the government to send her papers to the consulate. That can take time. But this is processing time. It can take 6 months, maybe even 8-10 months. But eventually, she gets processed through an interview in the consulate, following to join. Another very common situation for following to join, which we have dealt with many times, is this. For some reason, spouse is not eligible for adjustment of status. They are outside USA. For example, J1 visa. The spouse is a doctor, she has to be outside USA for 2 years, or he has to be outside USA for 2 years. But you are getting your green card right now. They can get following to join 2 years later. Okay, so that's another very common situation. Let's look at Sachin's situation. Sachin is on AOS, priority date EB3, April 2007. He's got an arranged marriage in the works. Okay, but I want her to come back with me. Well, H1, H4 is the only option. H1, H4. Because unless she's in USA, in legal status, she can't file adjustment of status. When you are outside, you can only do following to join. Okay. Could you speak towards or confirm if indeed this is the process? Yes, what you do is, ideally, that would be the quickest. Get your H1, get the stamping done. When you go for your H1 stamping, get her H4 done. Both of you travel to USA on H1, H4. If your priority date is current when you land, you can file for her 485. Otherwise, she can stay on H4, you can stay on H1. Okay. So that would be one easy way to handle this situation. And you can, of course, do an 824 for her following to join. But here's one interesting thing, though, Sachinji. I have known of cases, I think they're still doing it. You can confirm that. When they will not accept an I-824 until the 485 is actually approved, which is, I think, a very bad process. They used to have earlier the process where they would accept the I-824 even when the 485 was pending. I believe now they say wait until the I-485 is approved, then file 824, which is a crazy process. Double check what they're thinking is. I always like to look into these things closer to when I'm filing, because government does not write everything down for us. Many times policy issues or change in SOP, standard operating procedures, are not very well documented. Okay, so double check that. I'm happy to set up a further consultation. Well, I don't have anything else to add. I think you should file for an H1 also. I really believe that is the fastest way to do this. Okay. Anybody has a follow-up question on this issue, press *5. Doesn't have to be Sachin. Anyone who has a follow-up question on this issue, press *5. Okay. Let's go on. I think there's one more frequently asked question. Okay, this is another very common situation. There is a name variation. Okay, so let's say your name in your high school diploma in your college is John P. Smith, whereas when you got your green card or your H1, you put it down as Peter Smith. You used your middle name as your first name. India has many names, many variations. Spellings can be different, names can be different. So what should you do? I think one of the easiest way to remedy is to actually get a decree from the local court. And they have a very quick process. Usually you don't need a lawyer for these things. You can just contact the local court system and tell them you want to do a change of name. They'll typically give you some paperwork you fill out, you advertise in the newspaper, and then you can show that to the USCIS. But of course, you have to then also take care of your passport, your social security number. It's a little bit of a hassle, but it needs to be done at some point. You should have uniform names. In this case, that has been outlined for us by community member Remo Schweizer. I'm trying to understand what that name is. That case is actually, I think, just that. Because your new name, old name on the degrees and diplomas are different, so the government wants proof that this is the same person. It doesn't look like a very complicated issue, although I can see potentially other issues. But I'm sure your lawyers will advise you if that becomes a problem. As far as this RFE is concerned, the focus seems to be only on the name. Anybody has a follow-up question on name change, press *5. Okay, let's get started on the other questions one by one. So we did the gap. Okay, the gap in status. Mansa says, I'm on OPT extension ending May 1st. The new rule to extend 7 months will be effective May 10th. I don't think you can get an extension, Mansi, sorry. The problem is, from what I understand of the regulations, unless you have 150 days remaining, you will not be able to get that 7 months if your status is expiring. So H1 is your best bet. I don't think you can get an extension. *5 if you have a follow-up question. Anybody has a follow-up question on this issue? *5. Okay. Let's go on to the next question. Mohan, spouse traveled to USA on H-4 visa in December of 2015. She has an approved H-1B last year, but she didn't join. So did she get an H-1B visa stamping done? Because if she was outside USA and she did not get H-1 visa stamping done, USCIS, incorrectly in my mind, can take the position that she's not exempted from the quota. Until and unless you get a visa stamping done, you are not exempt from the quota. That's what the government is likely to hold. Okay, but if you are in USA and there's a change of status requested, and October 1st comes and goes, then you have become exempt from the H1 quota, whether or not you actually joined the employer. Follow-up question on this issue, *5. Follow-up question, press *5. So I think that is the problem you are going to have. Worth trying though. I think, like I said, government is legally incorrect in that insistence. Next question is DVN LGS wants to know, parents landed on March 19th on B2 visa, but their passport does not have an until date. Well, that process has changed. Now the form I-94 is available online. Okay? So you have to go print it out. So if you just do a search on print form I-94, it will direct you to a page within the Customs and Border Protection website, DHS CBP website, which will then ask for passport number, name, etc. and give you a screen of the I-94 which you can print out and keep. Okay. Any follow-up questions on I-94? Press *5. By the way, I am monitoring my Twitter account also. Okay, there is one hand. I am monitoring my Twitter account also. If you have any questions or comments while we are talking, immigration.com, you can actually tweet to me from immigration.com homepage as well as from the forums. On the right hand side, you'll see our Twitter feed on both pages. Okay, there's one raised hand on this, so let's go ahead and talk to him or her. Go ahead, please.
Hi, Rajesh. The question was posted by me, and thank you for that clarification. So, if I don't find it that the passport or the I-94 is updated, do I have to contact the Homeland Security local office?
Actually, Customs and Border Protection. CBP, yeah, if you go to cbp.gov, they'll give you a list of all the offices, and you can call and find out what their times are. I think they're called deferred inspection posts. So pretty much every airport, many of the inland offices, you can just walk in and ask them for the I-94. Actually, also CBP website, their search engine is pretty good. You can type a search for I-94. Maybe I'll say I-94 not found or something like that. And there should be some frequently asked questions on that. I saw them just a couple of weeks ago. It's on their website. It tells you what to do if you can't find your I-94. Okay?
Okay, perfect. Thank you so much.
You're very welcome. Good luck. Okay, so let's put that hand down. There's another hand up. Let's see what this is about. Pennsylvania, go ahead. You have a question, Pennsylvania? Okay, maybe not. Okay, there's another hand raised. One more thing I want to point out to you. I'm not doing new questions right now. I'm just answering questions about the I-94. If your question pertains to an I-94, keep your hand up. Otherwise, no. Go ahead, New Jersey. Go ahead, please. New Jersey.
Yeah, hi. Hi, this is Abhishek.
Hi, Abhishek.
Yeah, I had a question regarding I-94.
Right.
I looked it up online, and it seems like although my H-1B was extended recently, when I look it up online to get the latest I-94, I have a hard copy of I-94, so there is not an issue. But when I look it up online using my passport number, birth date, etc., it says I-94 not found, although I have a hard copy of it.
What happens is I-94, as far as I understand, I-94 that is approved through the USCIS, like yours must be, that will not be found on that system. Okay, you will not. You will only find the I-94s that are given to you or used to be given to you when you entered the USA from outside USA.
Okay. Okay.
CBP does not. Yeah, CBP will not hold on to those I-94s that are approved by USCIS. Only the ones they do, to the best of my knowledge. Okay.
Okay. Okay. All right. So in the future, if I do leave US and then come back to US, then I'll find an I-94 here.
Absolutely.
And
absolutely.
And after that, if I extend my visa again, would they update this, or would I then have to
when you file for an H-1 extension from within the United States, they will give you an I-94 with the approval. It comes attached to the bottom of the approval.
Yeah. Okay.
Okay.
Okay. So I'll use that.
Good luck. Good luck, Abhishek.
Yeah, thank you.
You're welcome, sir. Okay. Let's go on to the next posted question. This is from S.S. Santamu Richard. I need to know how much does US citizen visa cost, and I need to wire transfer to deposit money. The question is confusing. I think what you're asking is if you can just pay some money and get a green card or some kind of visa for the United States. The answer is no. It does not work like that. Do some homework. This is a very preliminary question. Do some homework, read up on it. US immigration is restricted to certain channels. You cannot just pay money and unless you're paying $1 million or $500,000. You can't just pay money. And there's a process attached to everything that's happening here. Okay. So 1 second. So yeah, so that question in the context of how we deal with US immigration does not mean anything. Okay. If you are on the phone, press *5. I can answer further if you have a question. Press *5. Okay. And there is a raised hand. No new questions, please. Go ahead. Michigan, go ahead, please.
Yes. Mr. Kranaditis Kranadi, thank you so much for getting connected. My situation is very unique.
Oh, hang on 1 second. Ma'am, 1 second. I'm not doing any new questions right now. Just follow up. So please stand by. I'll get to you when I do new questions. Okay?
Okay.
Yeah, guys, no new questions right now. Let's just take care of the questions that have been posted first. So Nishpal says H-1B started from October 2010 with company A, got the I-140. In 2013, switched to company B, got my H-1B beyond 6 years till December 2017. Wife is on H-1B visa. Company B is going through oil crisis, tough time. If I lose my job today, I'll have to switch to H-4. Will I be counted against quota if I go back to H-1B? No problem. You can do this for the next 6 years or so. You will not be subject to H-1 quota. So if you went from H-1 to H-4 and 3 months later found a job, you will not have to apply under the quota. You will be entitled to an H-1 right away. *5 if you have a follow-up question on this issue. Nothing new, no new questions. *5 for follow-ups. Okay, we've done getting married part. Then we come to OPT extension was denied because of incorrect fees. Oh, there is a follow-up. Okay, guys, try to be quick about it, please. I almost ignored you. Michigan, go ahead. Michigan, go ahead. Michigan. Okay. There are two Michigans who raised their hand. Okay, that's interesting. Or maybe it's the same number that got disconnected earlier. Okay, I can't tell what's going on here, guys. But unless it is okay, somebody from Minnesota. I'm reminding you guys, no new questions. Just follow up on this case that I discussed a minute ago. No new questions, please. Okay, Michigan. I'm not sure what's going on. Please don't keep raising your hand. And that's very distracting unless you have a question. Okay, all right. Let's go back to, so the problem, Srini, with OPT and wrong filing fees is there is really no way to go back to it. As far as I know, it's been over 120 days. As long as your second application was filed within the time permitted for OPT, you're okay. But if you run afoul of that time, the first filed application will not help you. And is there any way you can remain in the United States? H-1 is the only other way, or going back to school. I mean, those are the two obvious choices. Other than that, I don't see how you can, your situation can be helped. *5 on follow-up questions on this issue on OPT, what I discussed. *5. Okay, let's go on to the next posted question. So here what has happened is somebody has taken lucky man 90 has not physically attended classes. Can they get OPT? Look, I would advise you to step away from that OPT because government could consider that to be fraud. It really is not an issue I can comment about lightly. But if you ask for a benefit knowing that you're not entitled to that benefit, since you've been out of status, not having attended school, government could make an issue of it. Will they? I don't know. Can they? Certainly. Okay. So I think it can be a problem. Remember, OPT requires that you must have been maintaining student status, I think the last 2 semesters before you apply. And in your case, there's a gap because you did not physically attend the school. So I think that's a problem. It could raise other issues. I would advise you to go shoot for H1, and that too without change of status. Just go get H1 visa stamping and come back. That way, all the earlier status irregularities are removed. And if this issue ever comes up, were you out of status, just say yes and explain. You don't want to hide this. Okay. *5 if you are here and have follow-up questions. *5. Okay. All right. Solomon 07 in has an EAD and moved to another company after 180 days, filed AC-21. Okay. Previous company is going to revoke the I-140. Will that be an issue? Well, you have an EAD. So what you are saying, I'm assuming what you're saying is that your I-140 was approved and your 485 has been pending more than 180 days because that's why you filed AC-21. Assuming that to be the truth, a company's revocation of its I-140 of a case which is approvable under AC-21 is no problem. Okay, so if they revoke your I-140, I don't see any issue at all because you're entitled to your EAD and your AC-21 protects you. And the fact that your job for which you were approved was software developer applications, and the other job is the job being offered is computer analyst. See, in the IT industry, jobs really don't mean much. People are called programmers, but they're doing architecture work. People are called systems analysts, and they are doing quality assurance. People are called, programmers, analysts, and they are doing, system administration. So really, you have to look at the job description. As long as the job descriptions are same or similar, you're fine. Okay. *5 if you have a question. *5. *5. Okay. There are a couple of frequently asked questions. Then we come to from Sandeep Agarwal, B1, B2 visa in 1999 and overstayed for 16 months. You see, under the law, you would be subject to 10-year bar. And if you have been outside US, say already for more than 13 years, that is not a problem. You should absolutely answer the questions truthfully, whatever the truth is, because if you lie, you could be subject to other bars. For example, if you procure or attempt to procure immigration benefits through fraud or misrepresentation, it's a permanent bar from entering USA. And it's very difficult to get a waiver for those permanent bars. Okay, so please be truthful, and I would strongly advise you to do a consultation with your lawyers. Feel free to contact us if you want to consult us. I want to know more about your case. I want to know what your intention was when you entered. If there is any element of fraud, we need to deal with that. So, those are the things that you need to worry about, but obviously, whatever questions you're asked, you've got to tell them the truth. Otherwise, everything else is okay. You should not be denied an immigrant visa just because 13 years ago you have a 10-year bar. because by now the 10-year bar is done and gone. Okay. Follow-up questions, press *5. Follow-ups, no new questions. Follow-up *5. Okay. So the next question from Sri is, he's got short charged by 2 months on his OPT because it took USCIS more time to process the case. Can I make an appeal request to USCIS? Well, I think the process here, there is, as far as I know, there is no way to get those extra 2 months back. Okay, there is no process for it as far as I know. So if I had something to share with you, I would have been happy to. But that doesn't mean that there's not something out there that might be possible. I just don't know of any way to do this. You can try contacting USCIS customer service and then try contacting your local congressman's office, see if they can find out for you. But I don't think there's anything you can do. H1 is the only easy resolve to this solution, to this situation. I don't see any other quick way of dealing with it. Okay, *5 if you have a follow-up question, *5. Okay, no, okay, then let's go on to SPSN. I-485 was approved but received a second RFE for wife on bona fide marriage. Is it normal to receive second RFE? Yeah, it's not abnormal. I mean, it happens. Not the regular thing, not something the government should do very frequently, and they don't, but it is possible, it happens. Would it be okay to travel? The only problem is, if you travel and the case is denied in your absence or in your wife's absence, she will not be able to return. Okay, so that's the reason I would not advise to make that trip. If you really need to, then remember that risk. If you travel and, and I don't know how much time they have given you. RFEs, I think, give you 87 days. You said 84, but they also add 3 for, I think, mailing. So 87 days. Can they cut short the time for the second case? They can. They could give you lesser time in the second RFE. Okay. So really, I would not travel if I were you. *5 if you have follow-up question. *5. Okay. Next question is from Hassam. His 751 is delayed. His lawyer advised him to file a naturalization even though the 751 was still pending. I have never done that. So again, immigration law is vast. There can be areas which we may not know something about. I would always like to double check these things. I would probably not have filed naturalization, which is not to say that your lawyer is wrong, but it is what it is. I think what you should do is you should contact your congressman's office. Tell them what the problem is. They might be able to resolve this for you fairly quickly. Okay. *5 if you have a follow-up question. *5. *5 if you have a follow-up question. Okay. Let's go to Krish. Received on March 23rd an RFE for I-485 notification for myself, wife, and son. Son got physical mail on March 28th. Wife and I haven't received anything. What is the best way to contact USCIS? Krish, contact their general customer service number, 1-800, whatever that is on their website, and make your request known. Let me just double check my Twitter. Okay, that's not new questions. Okay, so going back to your question, I think the best way to do this is to just contact the USCIS customer service. Although 10-15 days time gap between when they issue and when you receive the RFE is normal. Okay, so if you don't get it by second week of April or so, I would then start getting worried. Other than that, I don't think it's a big problem. Okay, so next question. My SLAD says, Received intent to revoke notice from USCIS for company A H-1B. Moved to new client, but new LCA was not updated. H-1B amendment was not filed. What are my options? Reply to notice, of course. All these cases must be replied. More than you, the company would come under trouble. Reply and move to a new company. I have to know the case. I have to know the companies. But all these options are there. Another company B is ready to process my H-1B immediately. You probably will have to go outside USA for visa stamping, because if USCIS finds that you are out of status, that is not a permanent bar of any kind, but they will not give you H-1 within the United States. They'll ask you to go outside USA and get your visa stamping done. So that option is also there. Okay. I would want you to talk with your lawyers in detail. Talk with your lawyers, go over the case, see what possible issues there could be. As long as it's not something connected with you, it's connected with the company, there should be no permanent damage to your situation. *5 if you have a follow-up question. *5. Okay, I have two more. Okay, one hand has been raised. 1 second. Michigan, go ahead, please. Michigan.
Yeah, I have a question regarding that. My contract also finished in October 15, and right now I have a couple of opportunities, and they want to file my new H-1B, and they want to file non-profit H-1B. So for that, they want me to go out of border, and I don't want to go to India. Can I go to Mexico, Juras? That is a place everybody says a good stamping. Nobody got stuck there. So what do you think? Is that is a good option? And I never went to India since my H-1B approved. I never stamped before. So I am doing new H-1B. I mean, they are doing new H-1B. And I never stamped my H-1B before. I never left country before. So can I go for new non-profit H-1B to Mexico for stamping?
Hang on 1 second. Your situation is not really exactly the same. I'm going to ask you to hold. I'll get back with you. Let me finish my posted questions first. I'll keep you unmuted. Let me just. So Potter P385, I'm on H-1B for past 3 years. I-140 approved in EB2 with Jan 2014 priority date. Till now, I have worked for-profit organization Company A. Company B, non-profit, will transfer H-1. Company B is non-profit who will transfer my H-1 and sponsor green card in EP3. If I got transferred to Company B and 4 years down the road, I have approved I-140, I would like to move to Company C, profit. Will I have any issues? No. See, that's one part I'm not quite sure about, but I think this is the way it should work. So this is a question. H-1 question is separate from green card. H-1 question is, I'm working for-profit, so I am under quota. If I go to non-profit, remember, not all non-profits are quota exempt. A non-profit research organization, I go to them, they are quota exempt. Now, if I want to go back to for-profit, am I quota exempt? Or by taking a job with for-profit or non-profit research, I've lost my quota exempt status? My guess is, I don't recall running into this situation exactly, but my guess is you should not have a problem. Because within the last 6 years, if you have been counted in the quota, the fact that for a couple of years or 3 years, you went into a non-quota situation does not take away your quota exempt status. Okay, so I don't think it's going to be a problem, but I want you to double check it. Now, company is doing green card in EB3. There's a huge backlog. Company A agreed to keep my green card active. If I move to Company B and 8 years down the road, if EB2 becomes current, how can I safely acquire green card? Well, first of all, as long as when you file the 485, it is your intention to return back to that company, and that company does have the intention to take you back, you can file 485. After 180 days, you can join any company with the same or similar job. You never have to join the future employer. Okay. So you really may never have to go back. If you do want to go back anytime after or before approval of the green card, after the green card is approved within a reasonable period of time, maybe 3-4 months, thereafter you can join them. Okay. Follow-up questions, press *5. Follow-up questions, no new questions, please. Okay. Let's go to the last question of the day and then we'll start the new questions. Pravan has 2 sets of questions regarding H-4 EAD. So one question is, if my spouse has an H-4 EAD and my I-140 gets revoked, will her H-4 EAD be taken away? And the answer is, we don't know. USCIS has said that they reserve the right to revoke the H-4 EAD, but are they likely to? I do not know the answer to that question. They have clearly said that in their frequently asked questions, that we reserve the right to revoke the H-4 EAD where the underlying I-140, there should be at least one approved I-140 in play. If there is none, it's revoked, then we reserve the right to revoke the H-4 EAD. Okay, but will they do it? I do not know. So the new regulations, well, when will they come into effect? I have no idea. Okay. I really don't want to conjecture on that, don't want to guess on that. There is no way to know. Regulations are uncertain. They can take a month, they can take 6 months, they can be never, you never know. Okay. So that said, all the people who have new questions, excepting you, Michigan, your hand is already up. You don't have to put it up again. Everybody else, new questions, press *5. *5 for all new questions. I'll answer you in the order in which you logged in. All new questions, press *5. So far I have a total of 3 hands, including Michigan. So far I have a total of 3 hands. I will only respond to these 3 people, no more. Folks, make sure your hand is up. Okay, let's start with California. California, go ahead, please.
Yeah, my question is like my 140 was approved in 2013, but I came to know that my master's degree was from an unaccredited university. At the time I did my master's, but unfortunately, I'm not sure if it's a good sign or not, but USCIS has approved that 140. So what are my options here? Like, do I have any issues when I file for 485 when my priority date is correct? Or is there a way I can correct that?
See, here is the problem. If you got a green card under EB2 category using the master's, which is questionable, your case can be denied and the I-140 revoked before I-485 or even after the 485 is approved. Okay, so you get the I-485 approved, 4 years later or 5 years later, this issue comes up, though it shouldn't. They can go back and revoke your green card that they have approved for you. So it's a very unfortunate and dangerous situation. If I were you, I would file a new green card just to be safe. Okay.
So can I file the new green card with the same employer?
1 second, somebody just tweeted something to me. Okay, well, somebody just tweeted something. I'll deal with that later. So let's go back to what you were saying. Go ahead. What did you say? Last comment.
So can I file the new H1 with my current employer, or?
See, H1 I'm less concerned about for the moment. I would want you to start a green card. Was your H1 also approved under master's degree category?
No, the H1 was under bachelor's.
And can you tell me what your bachelor's degree is?
4 years BTech degree from India.
Yeah, see, 4-year BTech qualifies you for an H1. So I think H1 is not the problem, but green card you should start just to be on the safe side.
Okay, so I will lose the priority date on the first one.
Well,
Right?
that's something we can't really help. I would want you to start a green card again under EB2, but based upon 5 years of experience after your BTech. Discount the master's degree.
Okay.
Okay?
Okay, and I can do it with the same employer.
Why not? Absolutely. Good luck.
Okay, thank you.
You're welcome. I actually, guys, just to share with you a personal experience, many years ago, we had a case in which somebody went for naturalization and government told them, you shouldn't come for naturalization. We revoked your green card 5 years ago. But he actually had a physical green card. They couldn't inform him because he had moved and he didn't file AR11. It was a big mess. So here's this guy who's going for his citizenship. And he was, he was a Wharton MBA, very responsible person, a vice president for his company, supervising a couple of hundred people. Very smart man. And he'd been traveling on that green card for years. And they said, well, that green card is no good. Luckily, we were able to correct that situation because his wife was a US citizen. So, this can happen. We have seen such weird things happening. It's best to cover all your bases. Okay. Let's go to New York. Michigan, after that, I'll come to you. You are the last caller. So, New York, go ahead. You have a question?
Yes, thank you so much for all the assistance. My question is, I'm an American citizen. My fiance is a German citizen.
Okay.
He is doing a PhD in Stockholm,
okay.
but he's been in New York for the past almost 2 years now on a J1 visa.
Okay.
And he did not apply for a waiver of the home country requirements
okay.
When he obtained the J1 visa.
Okay.
So we will be getting married soon, and before his J1 visa expires. So we would like to apply for a green card for him, which I'm not sure if the right way to do that is with the adjustment of status is, I guess, the one question. And then the other question would be since he did not apply for the waiver before, would we need to apply for the waiver of the home country requirement now, or do we apply for everything at the same time? In other words, do we need to get that in advance before we can apply for everything else?
Okay.
And then I guess if you have any estimate of, in this situation, what the waiting time of things would be, because he also will have to return to Sweden to finish out some things with his PhD. And I understand that once the application for the green card is filed, if you leave without the travel authorization, you waive it. So it's just the timing even on obtaining the travel authorization or any kind of information you can help us with that as well.
This is the travel and all is the least of your worries. You have much bigger problems. The biggest problem is because the J1 is subject to a 212E home residency requirement, until you either get that waived or he goes outside USA back to his country of permanent residence for 2 years, you will not be able to get his green card. So there's going to be 2 years separation. There are only 4 ways to get rid of the 212E. 1, in some cases, no objection through your home country. So Sweden or Germany, whichever the home country is. 2, extreme and exceptional hardship to your spouse who's a US citizen, in this case you. And this is not ordinary hardship. We are talking about something major wrong. I can give you some examples, but it's not easy to get that waiver. Number 3, political asylum type problem. If I go back, I'll be shot. Number 4, at the request of an interested government agency, federal government agency. Okay, there is only 4 ways. There's no 5th way to get a waiver. So if he's able to get a waiver, you're fine. Then the entire process can be wrapped up within a year, and you get travel authorization as well a few months into the process, so you can travel. Okay, but the bigger problem is 212E home residency requirement. Unless you get that waived, nothing can happen.
Okay, and that's something we need to deal with before we would even get married?
That is correct. deal with that, I would very strongly recommend that start by getting an advisory opinion. Advisory opinion from the State Department, waiver review branch. They have their information online. So waiver review branch, advisory opinion J1, if you search for these terms, you should be able to get to the right office.
I'm sorry, what was the term? I'm sorry.
Waiver review office or waiver review branch, J1 waiver advisory opinion.
Okay.
What do? They don't charge you any money based upon just your request and a copy of the form DS 2019. They will give you an advisory opinion whether or not, in fact, your spouse to be your fiance is indeed subject to 2-year residency requirement. Because government makes mistakes all the time. Sometimes they mark cases subject to when they should not be subject to home residency. Sometimes they neglect to mark cases that are actually subject to home residency. So it's best to get an advisory opinion. At the same time, start looking into getting a waiver. Okay?
Okay.
That's
are these issues that normal people can deal with, or do you recommend these are complicated and we should retain counsel?
At least take a consultation with a lawyer. Spend a half hour going over the case. Let's look at the 2019. Let's look at what the program was, who sponsored it, how much money. For example, if it's a Fulbright scholarship, it's very difficult to get a waiver. Okay. If it is, I'm sorry?
It is not a Fulbright.
Yeah. So if it is a normal sort of non-Fulbright type, we have to look at the funding, where the funding came from, what the program prefix is it G or P, privately funded, governmentally funded. So many different things. At least some idea can be formed whether a lawyer is needed or what the chances of success are. So get a consultation.
Okay.
Good luck to you. Good luck, man.
Thank you very much.
You're welcome. Bye-bye. Okay, I'm not going to be taking new questions. Sorry. Please don't raise your hand. I'm just doing the last question from Michigan now. Sorry. Go ahead, Michigan. You had a question for me.
Hello, Mr. Khanna.
Yes.
Hello, Mr. Khanna. Are you able to hear me?
Yeah, go ahead. I can hear you.
Hello.
I can hear you.
Thank you. I was the one who tweeted actually.
Oh,
so,
okay.
Thanks again for doing this community service.
Sure.
I have a question which, sorry, I missed putting up the question ahead of time. I was an H-1B employee based out of United States in Indiana state. I got laid off in October 2015. I left USA and I have come back on B1, B2 visa in April 2016.
Give me 1 second. 1 second. 1 second, sir. 1 second. Did you request Monica to add that question at the last minute? Because one more question has been added. Is that you?
I sent an email to the
contact form. Because somebody, I don't do that because right now 2 more people have raised their hands despite me saying I'm not going to do no more questions. Raise your hands when I ask, not after that, because I've budgeted some time for it. Let me look at your situation. Give me a second. I don't deal with questions at the last moment, but I'll do my best. Let me just take a look at it because I have budgeted a certain amount of time for this call. Let's see. Recent work contract ended in October 2015. Currently not working. Currently I'm on H-1B visa. Visa is still active, not revoked. Original H-1B was approved first time in October 2011. I'm out of status, but my I-94 is valid till June 2017. I have a job offer. They want to file a new H-1B. Filing new, fresh, non-profit H-1B or transfer of current, which one is a good option for me? Look, almost certainly you're going to have to go outside USA for visa stamping. Okay? So be prepared for that. Whether you do it through a medical center, through profit, non-profit, it doesn't matter. It's the same problem. Okay? Are you clear about that, sir? I don't know what happened. I think I lost you. Okay. So, yeah, whether they transfer the H-1B, H-1B can be transferred. There's nothing stopping the transfer. But you will have to go outside USA unless the government decides to forgive you, which is very unlikely. Okay. You can also try going to Canada or Mexico, but you cannot come back on your I-94. And your employer should not have filed 1099s for you. H-1 does not allow 1099s. So bottom line, you apply for your H-1, whether transfer or non-profit doesn't matter, but be prepared to go outside USA. You can try going to a third country, but you cannot enter back on your I-94 if the visa is denied. Okay. Let's go to Michigan. Are you there, Michigan?
Yeah, I'm still here, sir.
Okay, so I just answered your question. Be prepared to leave. As far as visa is concerned, I don't care whether you file it as a transfer, which is an option, or as a new, you have the same problem. Okay? Sir? Hello? Don't know what's going on. Okay, let's go to Michigan. The second person is also from Michigan. Michigan, go ahead. You have a question? Yes, ma'am. Go ahead.
Yeah, thank you. Yeah, thank you so much for connecting. Yeah, so my situation is unique. I got layoff on October 15th.
Okay.
And my attorney, not attorney, one of my advisor, he told me, don't worry, I transfer H-1B to 6 months of layoff. And I refused some opportunities. Now I got some medical centers offers, and they want to file my new H-1B, and that's a non-profit H-1B. And my question is, do I have to go to India only, or can I go to Mexico for stamping to get the new H-1B?
There is a section of law called 222G. 222G. That has certain restrictions on going to third countries. I don't remember the whole section off the top of my head. My guess is you can go to Canada or Mexico also.
Okay, because Mexico is a very, very nice.
Yeah, you said that. You said that you wanted to go to Juarez. But yeah, Juarez is certainly an option. You'll have to look at the 222G. Make sure that doesn't hurt you. Okay.
And what is that 222G?
It has certain prohibitions against applying for visa from third countries if certain requirements are met. And government then said, look, this is not applicable to every case. We'll restrict it to some cases. And I don't remember exactly what the 220G restriction is, but that's the bottom line. Guys, you keep raising your hands. I'm not going to be able to deal with it. I said people who have raised their hands that this was the last call I'm going to take. No new questions. Sorry. Okay?
Yeah, one more.
Yeah.
So, should I go to transfer of H-1B if I have a for-profit?
It doesn't matter, ma'am. It doesn't matter. It's the same thing. You're not subject to the quota.
For transfer?
You're not subject to the quota.
If I have to,
ma'am, listen to me. Ma'am, listen to me. Don't get involved with the semantics. Not your job. Let your lawyers worry about it. Transfer, new visa, they are all the same thing. There is no legal difference.
The problem is right now I have for-profit, and the medical center will be doing non-profit.
It does not matter. Ma'am, it does not matter. Visas can be transferred like that. It's not a problem.
Yeah, but the medical center want to file new fresh, and the private employer, they will do transfer. So in that transfer, do I have to still go to India or out of country, or the transfer can be possible here only?
You almost certainly will have to go outside USA, unless the government decides to forgive your being out of status, which is very unlikely.
Okay. And sir, what is the risk at Indian end if I go to India?
I don't know the answer to that question. The fact that you are out of status by itself is not a problem. There are other antecedent issues, other attending issues. Your lawyers can advise you when they do the H-1. I cannot. I have to know the whole case.
So my advisor, he told me basically, he said, what we do, private attorney, he said, we will apply for change of employer.
Ma'am, is your employer a lawyer, ma'am?
No,
Then let it go. Let it go. Your employer doesn't know what they're talking about. Okay?
So can you hear me?
Yeah, we are going around in circles about the same issue. Bottom line, even after half an hour, is going to be only this. Apply for transfer, apply for new, I don't care. You probably will end up going outside USA. That's as clear as it can be, no matter how long we discuss this issue.
Okay.
Once you've been out of status for even 1 day, government can insist that you go outside US. Okay? Guys, I've got 5 more people raising their hands. I will not be able to deal with it. I'm sorry. I had budgeted 1 hour based upon the number of questions we had. I have to go on. My apologies, but I warned you beforehand that unless you raise your hand, I will only answer those 3 questions that were put. In addition to that, our team, in their infinite wisdom, had added another question, which I had told them not to do. I'll have words with them, but I'm not going to be able to deal with any new questions. 2 weeks, we'll talk again. Post your question ahead of time. That's the best way to do this. Okay? Good luck, folks. Thank you for your time. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.